Well, thank you very much. We're very fortunate to have some very experienced lawyers on the panel. We have gray hair, which equals experience. And some of us use Grecian formula reverse gray, so we can look older than we are. But in this group, I think we actually, our hair reflects our natural age. So what I want you to take away from this panel is that IP licensing for your project is critical to implementing your business model, and that it's complex. There are a lot of different legal regimes which apply to this, which means that there's a lot of ambiguity because it's new. I date back long enough to remember when software was new and we weren't sure whether software is protected by copyright. That's where we are for NFTs in many cases. And then the last point I would make is, so what do you do given those two things? Well, you can spend a lot of time reading legal text, which is not going to be very good use of your time, or you can hire lawyers, and I recommend this whether you're doing software, whether you're doing blockchain, or whether you're doing music law. You need to hire the lawyers that not only understand the law, but understand the technology. I would say more than anything, and I've been working in Silicon Valley for over 35 years, understanding the technology is critical here, because the way the technology works is going to determine how these legal rules, which remember copyright was designed for print books, get applied to these intangible objects. So now we're going to introduce ourselves. So I'm going to start with Ghaith. Could you give just a summary of your background?
Hi, everyone. It's Ghaith Mahmood here. I'm a lawyer at Latham & Watkins. I'm part of what we call our Data Tech Transactions Group. It's great to be here at NFT.NYC. I've been here a few years now and had the honor and pleasure of speaking to folks. What I do is, my area is really where does content and technology come together. So whether that's video games, social media, and really NFTs are that story, right? This is how we're using new technologies to commercialize, make, and really engage with people around new and cool content. So I've had the pleasure of representing a bunch of clients in the space, whether that's marketplaces like OpenSea, help Binance start their NFT marketplaces, Coinbase, a bunch of NFT projects, whether that's Azuki or OK Bears, a bunch of video game Web3 companies like Wildcard or Play Labs. And also one of the things we'll talk about, do a bunch with A16Z and help them write, along with Mark, our Can't Be Evil licenses, which are a set of open source, freely available NFT licenses that any NFT project can use when they want to decide, how do I want to allow the holders of my projects to have real rights in the artwork when they're buying my NFT? So great to be with you all. Louis?
It's a pleasure. Thank you, Ghaith. My name is Louis Cohen. I'm a co-founder of a law firm called DLX Law with offices in New York, Wilmington, Delaware, and Washington. And we're probably almost the diametric opposite of Latham, which is an amazing global firm with many, many, many lawyers. We're a very boutique firm, but similarly, we focus on clients working in the blockchain, crypto, and NFT space. And we try and represent, in a very boutique way, our clients very much in the round, looking at all of the issues that you face and trying to help craft solutions that are consistent with your vision and your technology.
So I'm Mark Radcliffe. I'm with DLA Piper, which is another global law firm. We have 4,900 lawyers in over 40 countries. As I mentioned, I've been practicing in Silicon Valley for over 35 years now. I have some of my partners here with me, some of whom are from LA and are in our entertainment practice, which has proved to be extremely useful in the world of NFTs, because entertainment rules are very different from software rules. It's sort of a crossover technology. But I've been doing both intellectual property and corporate securities during those 35 years. I've done over 1,000 venture transactions, and I've been quite involved in open source for over 20 years. I work with the Linux Foundation, with the Apache Software Foundation, as well as other open source projects. And that's kind of what got me into blockchain and digital assets. I'm also the co-chair of our blockchain and digital asset practice. And we think that being a global law firm is very helpful, because by their nature, NFTs and blockchain issues are global, as well as they cover a number of different areas of law, copyright, trademark, securities law, licensing law, and a number of others. And we're going to get, I think we're going to get a slide up that will demonstrate the number of areas of law that are part of being an NFT. There should be a slide with a platypus on it. So hopefully that's going to come up. But for those of you who are not familiar with the platypus, it's an Australian mammal that's egg-laying. It's duck-billed, otter-footed, beaver-tailed, and it has a poison spur. And when the slide comes up, you can see what the platypus looks like, but that's an NFT is like a legal platypus. And I have to thank Lewis, who mentioned this first in a Telegram chat group that we're both members of, about how the platypus best fits the complexity of the legal issues surrounding the NFTs and NFT licensing. So just so you know, the format is going to be, we're going to ask questions. One person's going to take the lead, then the other two panelists will join in, and then we'll go on from there. If there are questions from the audience, don't wait, just raise your hand and we'll see if we can answer them. So without further ado, let's get started with the first question.
Yeah, Mark, that's a great intro. And the title of our panel is Strategic Issues in IP Licensing. And so the most obvious question I have is, well, what are the strategic issues in IP licensing? What are the things that folks in the audience really need to be thinking about at the highest level as they, we talk about the Can't Be Evil license, but just at the highest level, where do you start? Where do you even start thinking about these questions?
Well, frankly, I would start by going to A16Z and taking a look at not only the Can't Be Evil licenses, but also the background material they put up there, which gives you a sense of some of the issues that you're talking about. And, Ghaith and I and Miles Jennings talked a lot about these issues and made some decisions, which, you may make a different decision. But for me, the top three issues, it starts with, is it going to be a commercial license or a non-commercial license? So, if you're doing NBA Top Shots, it's non-commercial. If you're doing, Yuga Labs, it's commercial with caveats because the original Barry Yacht Club license is kind of ambiguous. And then the second big issue is it exclusive or non-exclusive? So the idea is there a license which either is completely exclusive, which means you've given away all the rights, or is it a license that may be exclusive in a field of use? Maybe it's exclusive for movies, or maybe it's exclusive in other areas. Or is it totally non-exclusive, so you can do anything you want with it? And I think a really great license, which has come out recently, is the MeBits license that came out from Yuga Labs, much better than the Barry Yacht Club license. And I guess, and then the last question is, are you going to have termination, and what are the reasons for termination? And I'm sorry, that was the CryptoPunks license, not MeBits, sorry. But if you go back and take a look at many of the crypto licenses, they don't take into account whether or not you have a termination right. And so you can have termination for a number of reasons, just failure to comply with the license. So somebody, maybe you've got a non-exclusive, maybe you've got a non-commercial license, somebody's using it for commercial purposes, you want to stop that. Or maybe you have a no hate speech provision in it. So you don't want your intellectual property to be used in hate speech or for white supremacy or other uses which would damage your brand. And maybe you have a termination for that. But the point is, you need to think about that. And one of the areas that we had a lot of discussion around is, okay, we have a termination provision. How do we give notice? Does it terminate automatically? So in all my years dealing with open source, I'm going to tell you, automatic termination is a nightmare. It's part of many of the copyleft licenses, particularly GPLv2, and it makes it very difficult to figure out who has what rights, particularly if it's a complex license where it's difficult to understand what your obligations are. So I'm going to now ask my other panelists some thoughts on what they think critical issues are.
I mean, how transformational is that, right? Where you're able to say, I'm putting out some IP, and I want people to go buy it and make commercial products based off that IP that I put out. I mean, there's been some avenues of that, whereas mods of video games, Defense of the Ancients becomes as a mod of World of Warcraft, that becomes League of Legends, and yeah, we commercialized it, but was that really permitted by Blizzard when that was happening? You know, there's a whole history there. But we now have a way for projects to say, hey, here's some IP, go make money off this, and you can keep that money that you make. You want to take your Bored Ape Yacht Club or your Azuki project, and you want to put that in a movie, or you want to make a TV show out of it, or make a music album out of it, have at it, and you keep your money. And that's really interesting. But what we see is there's some projects that are like, well, hold on, am I cannibalizing myself when I let my users do that? I'm basically saying, hey, users, go compete with me, because I want to be an IP company too. I want to make movies. I want to make music videos. But my own customer base, my own user base is going to make the same thing. And so sometimes you see projects trying to thread that needle, sometimes in okay ways, sometimes in ways that I would say is just rubber stamping that, okay, we've given some commercial rights. Or let's say, yeah, you can commercialize this, but you can't make more than $50K a year. Or you can commercialize it, but your commercialization is really just merchandise and slapping it on a t-shirt and selling it at NFT.NYC or something. Is that really the same thing as a full commercial right? And so those are some of the strategies that you have to think about. It's not just simply toggling commercial versus non-commercial. And that's really interesting, right? Because it segues into one thing I want to ask you about, Louis, which is the securities laws that are underlying NFTs. There's a real fundamental difference when you can say, by holding this NFT, you have the right to go do stuff that is really valuable. You have the right to make commercial products out of this, and that's how you as the buyer are gonna have an ability to make money, versus, hey, hold this NFT, sit on it, hang out, don't really do anything, let me do all the work as the NFT seller. I'm gonna go try to make a whole bunch of hype and energy and buzz around this, and guess what? You're gonna be able to flip this NFT for 5x how much you bought it for. Those are two very different models, and one, I would say, probably has a little more risk on the security side. How would you feel about that,
Yeah,
Louis?
100%, Ghaith. And we got to, let's say, quick question.
I have a question building off of what you're saying. For a small brand who wants to actually protect their IP in Web3 to maybe avoid that happening, what do we need to think about so we can actually
100%.
Yeah, can you repeat the question too?
Yeah, so the question was, if you're a small brand, you want to go let people do cool things with your IP, but you also want to protect how it's used. How do you thread that needle? So there's a couple things that you could do, right? One of the things what Mark is talking about is building into your license certain revocation rights. So this is a conversation that we have with a lot of projects. You want to go let people do great things with your IP, but you're going to build in some prohibited conduct. So we had some projects that didn't want to let people use their artwork with alcohol or with certain types of paraphernalia that just wasn't in line with, they wanted to be family friendly. And so they built in those restrictions, and they built in those the ability to revoke the license if that happened. We had other projects that said, that's not very decentralized. Like, I can't be Web3 and be policing how my IP is used. I need to let the community go and do that. And so they were very zealous about not having revocation rights. That's a strategic angle. The second thing,
My question was, what if you need to protect your copyrights in Web3?
yeah, so the second thing is let's distinguish the trademark from the copyright. That's really important, right? So when I get the right, let's use, I don't know, Azuki is an example because I just talked about them. So let's use Azuki an example. So this is like, artwork that you have. In the license that you get a license to the artwork. You don't get a license to use the Azuki name and brand. Those are two very different things. That is, one is a license to use that really cool image of the skater with the samurai sword and just like the whole aesthetic vibe of that artwork. But you can't go out and say, this is an Azuki project, because the trademark is what identifies the originator of that good. You need a trademark license to be able to use that brand. And so one of the things that people say is, you can make derivative works, but you can't use the brand. You have to call it something else. So with Bored Ape Yacht Club as an example, you have one of the more famous derivative works of Bored Ape Yacht Club is what? Jenkins the Valet. Folks familiar with Jenkins the Valet? So you'll look, it's thoughtful. There's no Bored Ape. There might be a reference to say Jenkins of LA grew out of the Bored Ape Yacht Club, but they don't say this is a Bored Ape Yacht Club project or this is a Yuga Labs project. This is a Jenkins of LA specific project that's made by a specific team that has nothing to do with Yuga Labs. And so that's a really critical way to be able to distinguish the quote unquote derivative community projects from the first party original projects and have those kind of live separately.
Yeah, there are going to be other panels on trademarks, but I would like to, talk a little bit more in general for the rest of the audience. You can certainly see Ghaith afterwards, but I really think that security law issues are very important. So because if you're, if we had my slide of the platypus up, you'd see securities law and the poison claw, because securities law can make your project untenable. And Lewis is one of the leading thinkers on the application of securities law to digital assets. So first I'm going to ask if we can get the platypus slide up, please, for the, could you talk with LJ, because he's got it. Okay, fine. No platypus.
We're
Okay.
giving up.
It's
We're bailing on the
camouflage.
platypus.
Okay.
We're gonna, yeah. So I think folks are at this point very familiar with that poison tail. I love that, Mark.
Yeah.
In general, as to crypto, as to general assets, and I think there's been, perhaps a sense that NFTs get a pass in all this, and we have clients come to us and say, well, no, don't worry about securities law. It's an NFT. We don't have to worry about that. And I think even there, people at this point understand concerns around fractionalization. Say, well, we're not fractionalizing, it's just one NFT, we're all good. This is a panel about IP licensing, so why are we talking about securities law? And I think, Ghaith, you absolutely touched on this. IP can and frequently, constantly, is licensed without triggering securities law issues. So for example, I may have a publishing portfolio of music rights, and I might sell that or license it to an investor, to a hedge fund, right? There are a bunch of funds like that. That's not a securities transaction. Where the line starts to get gray is where you associate a financial right with a tradable object, in effect, whether you want to call that an instrument or you want to call that something else. But it could be a jelly bean. It doesn't really much matter. It's saying, hey, if I give this to you and you give it to somebody else and you give it to somebody else, all of you benefit, as you were explaining, Ghaith, from the efforts of someone else. Your purchase of that asset at that point transforms from something that is consumptive, which is the word we use in securities law, where you have an interest in the asset you're acquiring to use it in some way, either because it's a beautiful image and you want to put it on a wall, or it's something commercially valuable and you're going to exploit it. But in those cases, you're buying the thing to consume it in some way, to utilize it. When you transform that from something that's consumptive to something that's been financialized because the NFT comes along with financial rights. Oh, I licensed it 3 owners ago. Somebody cut this amazing deal to make a film out of this particular character, whatever it may be, and now that NFT comes with the rights to 10% of all the revenues from all this IP in perpetuity. You think, man, I'm going to estimate how much cash flow I'm going to get, and I'm going to buy that NFT so I can hold those rights. All of a sudden now, you've turned something that was consumptive in nature to something that is financial in nature. And that line, sometimes it's obvious when you're stepping over it, and sometimes it's not so obvious. In a lawsuit against Dapper Labs, in a civil case, there was an allegation that basically they had created an arrangement that was more like an investment than a consumptive interest because people were primarily interested in the financial side of things. Mark, I want to ask, for me, what is one of the more interesting and critical questions when you think about tying together what Ghaith said and what I said on securities laws, and that's termination of those licenses. Because really where you start to get into trouble is where the financial rights run with a transferable NFT that's tradable on OpenSea, and all of a sudden becomes like a financial instrument. So talk to us in our little remaining time about termination of IP rights.
Yeah, so we're going to have to be very quick about this because but this issue was, we had a great discussion between Miles and Ghaith and I about what you should do about termination, what happens to the sub-license upon termination. So let's say you've got your Bored Ape yacht and you've licensed it out to do a motion picture, you've licensed it out to do a clothing line. Now you sell the Bored Ape. So what happens to the guys with those sub-licenses? So you have a couple options. Option number one is they all get terminated. That's what we chose for the Can't Be Evil license on the basis that it provides some lowering of risk of securities law, but also because we wanted the person buying the Bored Ape, the NFT, to know what he's getting. A second one would say, okay, those rights are frozen at the time of the sale. So whatever's been licensed has been licensed, those rights are frozen. And then the third one would be more generous and say, okay, well, the people that get the people that had the licenses, sub-licenses at the time, they can continue to make other derivative works. And this is not a problem, frankly, just in NFTs. It's a problem in copyright and in other areas. So unfortunately, we're coming to the end of our time. But once again, what I'd like people to remember is the takeaway is getting the licensing rights correct at the front end is important on implementing your business model. Because otherwise, you implement the lawyer's business model, which is litigation. Every lawyer loves litigation, okay? Because you go ka-ching, and you're probably dealing with people who are over $1,000 an hour. I mean, the FTX was $30 million, although not just legal fees, some advisory fees. So the net of this is, unless you want to spend a lot of time with lawyers away from your company, you don't want to get into litigation. So get it right the first time, and to get it right the first time, you need to understand the broad concepts, but also you need to get a lawyer that understands the concepts and understands the technology.
An ounce of prevention worth a pound of cure.
That is correct.
I mean, there's so many cool topics that we just didn't have time to talk about, like what happens to derivative works? Should I use CCO? What happens if I use the CCO, just give it all to the public versus actually having a license to it? How do I deal with royalties now that Blur and a whole bunch of other marketplaces aren't allowing me to make royalties on secondary sales? So many cool topics in this. If you all want to talk to us about it, come find us afterwards. I'm happy to chat on it.
Thank you very much.
Thank you.
Thank you.
Thank you so much. You can just leave your mics on the chairs.